One of the most difficult and troublesome wage and hour issues for employers to deal with is the classification of workers as independent contractors or employees. Independent contracting relationships can be very beneficial to employers and also to workers, and they provide for increased flexibility and more freedom in defining the terms of the relationship. First, the standard that an employer needs to meet in order to show that the workers that is working with are independent contractors versus employees is an extremely difficult one to meet, especially here in Massachusetts. To begin with, there's a presumption here in Massachusetts that any worker is an employee and not an independent contractor. So you're starting off with one strike against you right off the bat. And then to overcome the presumption, you have to make three showings. You have to show all three of the following conditions have been met. First, you have to show that the worker, in performing the tasks that you've asked him to perform, is free from the control and direction of you, the employer, which can be extremely difficult to show in many cases because often, for understandable reasons, the employer wants to be able to exert some measure of control over how the people that are doing work for it perform their tasks. But in Massachusetts and in other states as well, doing that can make it very, very difficult to show that the person is actually an independent contractor versus an employee. Second, the employer has to show that the tasks the employer is performing for it are not within the employer's usual course of business, and this can be extremely difficult to show. Basically, it means that an employer can't hire an independent contractor to do any of the kind of work that the employer regularly performs. Anyone that hires to do that kind of work has to be an employee. So, for example, if you're a same-day delivery company and you want to contract with independent drivers to perform the deliveries for you, you can't do that. You have to hire those people as employees. That can have a tremendous adverse effect on the company's profitability and its ability to survive. And in fact, a trade association for delivery companies recently filed a lawsuit here in federal court in Massachusetts, and their claim is that this independent contractor law and the specific provision of it that prevents them from hiring independent drivers as independent contractors is preempted by federal law. Third requirement, or the third condition that employers need to show, is that the worker is doing the same type of work for other employers that it's doing for the employer at issue. And that can be extremely difficult to show also because it's often the case that that is not within the control of the employer and is not necessarily even within his knowledge as to what the employee is doing when he's not working for the employer. Classifying workers as independent contractors is extremely dangerous, not only because it's difficult to prove that the person is an independent contractor, but also because the penalties for making a mistake can be extremely onerous. In Massachusetts, we have automatic treble damages assessed against employers under statute for violating and misclassifying employees. There's also the possibility of attorney's fees and costs being assessed against employers, as well as criminal and civil penalties assessed against employers by the state, including fines as well as possible jail time, even if the violation is not done willfully. So we recommend that employers be extremely cautious in entering into independent contracting relationships with workers, and to the extent they're already employing independent contractors, they should have someone come in and take a look at those relationships and make sure that they comply with the law.